excited to be here today and talk to you all about seller financing. I don't know how much in this crazy market, if that was something you were still seeing a lot, or if it's something you're seeing more of. I know there was a gentleman here who says that he had a listing with seller financing on it. And so it still is happening. But I didn't get the sense that it was happening quite as much as it used to be. What do you all think? Yeah, not as much.
It's
When
happening.
people are offering boatloads of cash.
Well, when they have such a great rate on their home and can sell it off and actually gain interest on what they're doing with seller financing, it's a great option.
Yeah,
So we are seeing more of it
Yeah.
On the broker side
Especially this
anyway,
low,
agents coming and saying, hey, what do we do here? So
yeah, glad to hear it. Yep,
Yeah.
and so as this cartoon points out, is an alternative to traditional 30-year mortgage. That's what seller financing is. It's a good alternative to traditional financing. And so today, let's see if this clicker will work. Don't know. Oh, okay, there we are. Now we're at the agenda. So today we're going to talk about what is seller financing, why you'd want to use it, how to structure that. So all of the what, whys, hows, so you can have your strategy and your tactics on how to approach these situations. But probably the most biggest thing that you have to consider is this even possible? As we're going to talk about today, there are some types of situations in which you cannot do seller financing. So what is seller financing? It's the first slide said, it's an alternative to your traditional financing. So in this situation, the seller steps in the shoes of the lender. They lend the money to the buyer to purchase the property. This is useful when traditional financing is difficult to obtain. And you can use, it doesn't have to be one or the other. You can use a mixture. Let's say they can qualify for some loan, but maybe not all of it. You can do a little bit of a mixture with it. And then typically it's shorter term than a traditional financing. It's pretty common to see a 5-year term on it with a balloon at the end. Is this working now? Yes. Okay. So from this, yeah. We can turn off the light. I don't mind. Yeah, thank you. And so from the seller's perspective, the pros of this situation would be maybe, your particular buyer can obtain traditional financing. So this allows the deal to continue. And then you can also earn a lot of interest. If you're going to do a seller financing arrangement, you really ought to consider doing much higher interest rate than what you're seeing with traditional financing, because it's a lot more risky for you as a seller to be the lender. And then it can distinguish your properties from other listings, particularly in a slow market. And then if I added this, if you need to buy time, this is something I recently came across in one of my cases with a client who owned a property in a trust. They had a lease with an option contract, but didn't quite understand what an option contract was. And so when the buyer came and said, we want to exercise this option, they said, wait a second, we didn't want to sell this until after we had passed away, because that was part of the estate planning. That's why it was put into the trust. And so when they were told, hey, we want to purchase the property, we want to do it now, that created some issues and concerns with the heirs who were concerned about capital gains taxes. And so in this situation, what we were actually able to do was arrange for a seller financing transaction. That way it buys more time. The client is pretty elderly. She's in her 90s. And so she figured if she structured it this way over the next 5 years, maybe she might pass. And then that might help with the issue of her capital gains. And so this was a brand new bullet point that I got to add because it was something I recently dealt with. So if you need to buy a little bit of time on the transaction, that might be something to consider. And then the cons for the seller is that if you need the proceeds from the sale to close on a new property, that's not going to work very well if you're not going to get it all up front. And then also the risks of non-payment. We're going to talk a lot today about what happens when these deals go sideways. And there can be a lot of stress involved with enforcing these deals. And then also it can violate any sort of due on sale clause if there is an existing mortgage on the property. If a mortgage lender sees, hey, this isn't the person that I lended to on title, then that might trigger their due on sale clause and say, well, now it's all due because that's you violated the terms of our agreement. And so that's to keep in mind from the seller's perspective. And a lot of people think, well, is it really going to happen? Is the mortgage really going to call the note due? And this is an example. You have your, maybe we need to change these numbers because I have not seen a $300,000 property in a long time. Yeah. But this is just an example of what you kind of see with some different terms and interest amounts of what that actually makes a difference. And so, the hypothetical here is if you were the banker looking to increase interest revenue and your bank has 500 loans on the book that you could call due, if it calls it due, that adds a bunch in interest revenue that you could be getting commission of. And so what do? You might call it due. And so this is just an example of it could happen. There might be incentives on why they might want to call it due, even if it doesn't happen a lot.
It does happen though. I've had
Yes.
2 in 32 years.
Yep. And that's why you really want to make sure when you're structuring these transactions, we'll talk about it today about some key terms of what to do if that happens. But also you have to keep in mind with structuring it as well, work with the mortgage. Don't try and do this in secrecy. You want to work with the underwriter to make sure that you are structuring it correct and that there isn't any surprises. Okay, so back. From the buyer's perspective, again, a pro is if you can't obtain traditional financing, this is a good way to get a property. I see a lot of just individual investors that love this tactic because it means that they don't have to put any of their money down. They just get to approach sellers and say, what do you think about seller financing? So there's a lot. It's very popular for just investors to try to utilize this method. And I do unfortunately see some predatory practices as far as foreclosure relief with these types of transactions. Oh, hey, I'll take over your mortgage for you. You're in foreclosure. It'll be great. But the problem is, especially with individual investors, is there isn't a lot of that oversight. Like the licensee is regulated when it comes to offering foreclosure relief, but individuals out there who traditionally employ these methods, there's not a lot of guidance for them specifically. And so sometimes I see these deals that are very predatory. And so that's something to keep in mind. But
Question.
yes,
When you're saying it's predatory, who is the user side in that?
a lot of the time it's the seller, it's the people who are told, hey, I'm going to come in and get you out of foreclosure, but don't realize what they're really agreeing to, that they're basically becoming the financier for that investor. And they don't realize as well about what happens with title being transferred. They think they're still the owner of the home in a lot of these scenarios.
In 07, 08, 09, there were investors that were horrible about this.
Yeah.
They go in, they tell them, they catch the loan, they bring the loan current, they make monthly payments. They have the owner move out, and then they put up for rent. And if they couldn't get a renter, they weren't making the monthly payments.
Yeah, exactly. Yeah. So, and it really, it's important specifically, I mean, buyers got to know what the deal is because that's what they're, approaching the seller with, but the seller really needs to understand what exactly this means. And so if you have a seller that you're helping, it might not be a bad idea to put them in touch with an attorney to help them understand their legal rights with respect to the property. Because like I said, it isn't uncommon for sellers to do the seller financing and then to think that I still own the home when they really don't. They're really just become the lender, and you have to go through a foreclosure process. You can't just go knock on the door and say, you default to give me my home back. And so that's really important, whether it is a licensee helping a seller with this or an individual investor. It's important for everyone to truly understand what they're agreeing to and how it works. And then for the buyer's pros, there's also the faster closing process, also oftentimes lower closing costs, flexible down payments, and the terms are more negotiable, because if you ever tried to negotiate with the mortgage lender, it doesn't go over well usually. Usually they say take it or leave it. So when you're dealing with individual parties, it makes it easier to negotiate some of those terms. And then the cons for a buyer might be you're typically getting on the hook for higher interest rates. Again, it's more of a risk for a seller. That's something that, you know, if you want to get all of these pros, it comes at the trade-off of typically a higher interest rate. And then you got to make sure that the seller's lender approves of it. And then most likely you still have to prove credit worthiness. So just because your credit might be so bad that you can't obtain traditional financing, the seller's still going to want to know who they're doing business with. And so you do need most of the time, the buyers are still submitting credit checks and all of that type of information. And then a seller financed loan is subordinate to the seller's mortgage if there is one on the property. So you might be taking the property already encumbered. So like I said, the big question is not necessarily what is it or how to do it, is can you do it? And you can't use seller financing for any FHA loans. This is actually from a HUD letter dated December 14th, 1990. And you know, it's talking about sanctions that were taken against title companies and brokers who circumvented this rule and did it anyways. And so they are actually, if you're a licensee and you get caught doing something like this, you're placed on a blacklist essentially. And that could be from 1 year to life from helping anyone close on these types of transactions. So it's really important that if you are helping a seller with this type of transaction or even a buyer, that you're not wrapping any FHA loans. Now, there might be an FHA loan on the property and maybe it's able to be paid off as part of the transaction. You know how I said you could do mixed traditional and seller financing. And so maybe it gets paid off and then you can still do it. But just be aware there are certain types of loans. This says FHA and VA. My understanding is there is some changes that's happened with VA loans. I don't know the particulars. And so I would say if it's an FHA or VA, have a big old red flag of, can I continue with this type of transaction? And then if it is a VA loan, maybe go talk to an attorney to make sure that you're following those protocols there. So this is our case study number 1. We've got Joe Broker who agreed to close a transaction wrapping around an existing FHA loan because the buyer could not obtain bank financing. Joe thought there would be no issue with FHA because HUD would never know the wraparound had been executed since he was using a UREC, which we'll talk about. That's one of the types of financing. It stands for the Uniform Real Estate Contract. And the recorder, so he thought in this situation, because that's what he was using, the recorder wouldn't show any transfer of title. However, 13 months after closing, the buyer stopped making payments. Seller had to hire an attorney to foreclose on the buyer's interest, but the foreclosure sale left the lender $50,000 short, and the lender filed a claim with FHA to be reimbursed for the shortage. And so that's where they found out about this situation. And then they began an investigation, found that Joe is the agent that closed on the deal, and then Joe was placed on the excluded parties list system and was not able to close on any of those transactions or FHA or HUD sales in the future. So don't be like Joe Broker. make sure that you're doing your due diligence if you are structuring these types of deals, and make sure that you're not wrapping any sort of FHA loan with the seller finance arrangement.
Hey, Carly.
Yeah.
Just one thing to that, if you were an agent that got put on that list, more than likely the company would follow.
Broker, yeah. Yep.
So means that you eliminate any FHA transactions for the entire brokerage.
So don't do it.
So Rob, in that case, if you essentially fire the agent, for the company would get back the ability here.
It would be up to FHA
To decide how much
decide if they're
involvement.
going to
or
grant us that off,
Yeah.
that ability or not.
Yep.
So that's how big of a deal that is.
So let's talk about the types of seller financing. You have just a regular old deed of trust, and that's when the seller owns the property outright. Then you have an all-inclusive deed of trust, and this is also known as a wraparound mortgage or purchase money mortgage. It just acknowledges the existing obligations. And so that's why it's the existing mortgage is being wrapped by the seller financing deal. And then we have the uniform real estate contract, which is also known as a contract for deed, installment land contract, installment sales agreement, land contract, or a poor man's mortgage. And then you have equitable mortgages, which is, it's a type of seller financing, but it's really not something you guys want to be involved with, because it's just if it looks like a mortgage, walks like a mortgage, and quacks like a mortgage, the court's going to say it is an equitable mortgage, whether or not that's what you called it in those documents or anything like that. And I've never seen anything about it, so I hopped on Google and was like, why does this even happen? Why is it even a thing? And apparently it was something where people were trying to get crafty and get around the foreclosure process by not calling it a mortgage. But the court said, again, if that's really what it is for all intents and purposes, then you're not getting around the foreclosure process. So let's talk about each of these options, what you're going to need for them. With the trust deed and the promissory note, then you have the seller, they own the property outright. You have a promissory note, which is the contract wherein the buyer becomes personally liable for the debt for the purchase price of the property. And so it's essentially their promise to the seller, and it outlines what the procedure looks like if there's a default and all of that. And then you also have the trust deed, which that's what you see with mortgages. That's what's recorded on title with their instruments as well. And so it is very similar. You're just becoming the lender if you're the seller in these arrangements. And the trust deed transfers title, allows for title to be transferred to the buyer, and then it creates a security interest for the seller. The difference between an all-inclusive is that if there is a mortgage that is not FHA or VA, then you can do a promissory note, same thing as the last one, and then an all-inclusive trust deed. And again, the only difference here is that it acknowledges what the existing mortgage is, and that it specifically says that the interest is junior to the existing mortgage and all of that. And in these types of arrangements, it's very, very important to get a third-party servicer to make sure that when payments are made, that they're actually going to the right place, because that's where a lot of these things go sideways. Is, well, I've been paying you. I've seen for both sides where the buyer stops paying the seller, but I've also seen the buyer actually making payments to the seller who's not making payments to their mortgage. And then a foreclosure on the mortgage happens, and the buyer goes, what the heck, So that's why it's important for both sides to make sure you have a third-party servicer who are applying payments as they should be. Trust deed considerations. When you are thinking, this is how I'm going to structure this deal, this is what you have to think to yourself. Is there an underlying mortgage? Does the underlying mortgage have a due on sale clause?
Sorry,
You're just fine.
before you jump onto that, when you say that third party servicer, like,
Yeah, so you could do like an escrow or a title company, just a third party company that can make sure that payments are being distributed as they should be. Yep. Okay. And so you'll want to think, is there a mortgage? Does that mortgage have a due on sale clause? And it must comply with the first mortgage or the entire debt becomes due. And then is the underlying mortgage FHA or VA? Will it be paid off or will it be wrapped? Because if it'll be paid off, but even if it's a FHA or VA, then you can still proceed with this transaction. Is the seller willing to wrap? Are they comfortable with this type of arrangement? And then if it's a wrap, who are you going to get to service the loan? This is how you enforce a trust deed, whether it's an all-inclusive or just a regular old run-of-the-mill trust deed. If the buyer defaults, the trust deed and promissory note are going to provide for penalties. That's going to be late fees and interest. It's also going to have an acceleration clause, just like you'd see with a traditional mortgage that says, if you default on this, I have a right to call it all due. And then it also provides for non-judicial foreclosure, meaning just like the bank can start a foreclosure on you, so can the seller. And that means that there's no court involvement. You've got to comply with the procedure, which is statutory. It's approximately about 5.5 months process, which does give about a 90-day period for a right of redemption for the defaulting buyer to be able to pay it all off. And if they don't, then it can be sold at auction. If it's a wrapped mortgage, you're likely, if you're the seller, going to need to pursue a deficiency judgment, which means if there is a whole mortgage on the property and then you also have the seller financing arrangement, there's not likely going to be enough equity to pay off everything that's owed on it. And so that means if you don't pay off all that debt, you have to petition the court for a deficiency judgment after the fact and say, I didn't get everything I was entitled to under this loan. And so then you ask the court to get you a judgment for the remaining amount, which is something to keep in mind because going through a non-judicial foreclosure process, that's already a 6 months deal. And then you add a lawsuit on top of it. It just makes it takes longer. And then you have to, your main asset that's been secured is no longer there anymore. It's been sold. And so then that leaves you, once you get a deficiency judgment, you got to figure out if this buyer has any other assets that you can use to collect the remainder. And so it does become a much longer process if that's what you have to do.
I have a question.
Uh-huh.
Then if we are a non-traditional estate, but for example, can a seller do something that is judicial or?
Sorry, what?
Like we are a non-traditional estate for foreclosure.
Uh-huh.
Then if it's a seller, he can go and choose to do a different way.
So what the deficiency judgment means is that they've already foreclosed and they didn't get everything they were owed because they had to pay off the mortgage first. And then anything on top of that went towards what the seller was owed. And so then they've already done the non-judicial course. Then they're only left with having to go to the court for it.
If the seller, if he sold an investment property and there are renters in there, I'm assuming that in the way it's written up, the rents would go to the.
Yes,
So-
oftentimes you do see clauses that say if the buyer defaults, you can go and collect the rent of the renters directly and all of that. That's a great point because you do want to, particularly if you are going to have a seller financing on an investment property with renters, and that's another third party that haven't even signed your promissory note or trustees aren't a party to that agreement. Then you definitely want to make sure that you have built in those safeguards. Yep. Okay, so let's talk now the other type, aside from the trust deeds, whether that's regular or all-inclusive, you have the UREC, the Uniform Real Estate Contract, aka contract for deed. That's what Joe Broker thought he was doing. That's why he thought he was so smart, because under a trust deed, that's very easy to allow for the title to transfer to the buyer right off the bat. But with the contract for deed, that's not how it works. It's after they've paid off that the deed will transfer to the buyer. And so Joe Broker thought he was pretty smart because it wasn't going to show on the title abstract that the title had changed. But then, of course, we know in that scenario, there were other ways that he was discovered. But it's also important to note that even though title does not transfer, you record this type of contract on title. That way it puts third-party purchasers on notice. The seller can't just go and sell it to someone else when they've already contracted for it. And so that creates a situation where now everybody that could want to purchase the property has reason to know that they might not be entitled to this interest.
One question.
Uh-huh.
So, say I went and bought a property within a year.
Uh-huh.
And so I'm not on top of the seller is. Say, they got trouble with IRS or they had to bail bond.
Yeah.
Should
Now
that
there's
then
another-
be filed on my property?
Mhm. Yeah, so there can be additional encumbrances. You would want the contract to say that you're not going to put any other encumbrances and vice versa. Did you have something to say, Rob?
Yeah, so just in general, so people are asking me all the time, "Oh, I understand, Rob, you're not okay with doing seller financing. And that's not the case at all. What we're not okay doing are these.
Yeah, a lot more messy.
This is, and let me give you a little bit of, a couple of reasons why. There are, I believe there's only one that I'm aware of. First part of the challenge with this is there's only one title company that will insure these type of transactions. And when we're looking, and then we've also talked to numerous attorneys that have said that this is something that they would not do, but if it was done, then an attorney should be involved in making sure that it's done properly. Because no matter what, you're still going to have a challenge to get this transaction insured by a title company. They won't, and when I'm saying a title company, you also have the title, the company that insures the title company. And those writers, you can't obtain for these types of transactions. So doing a trust deed and all-inclusive, great. I have no problem with that. Make sure you're communicating the due on sales potential with your clients. They know that. But these are the ones that we are not okay with.
If you do a contract for deed, does the buyer get mortgage interest write-off?
That's a good question.
They don't
I
own
actually
property.
don't,
They don't have time.
yeah.
Check with their tax account, but my guess would be the answer would be no. Why would the seller want to relinquish that benefit?
Yep. And we'll go over in just a minute, kind of a side-by-side comparison that points out what Rob was saying about why, even though a lot of people look and think, oh, this is safer, I get to remain on title while they're paying me. There's so many reasons why this can be a much more.
Even just the title itself. The other way on a trustee or an all,
Yep.
you're getting a deed.
Yes.
That's part of you're getting in return. You're actually getting a deed. You get a contract.
Yep.
In lieu of a deed in this one.
Yeah.
Then you're like, what does that matter? It's a piece of paper. No,
The problem is it's a piece of
it's a
paper.
piece of paper with a lot more backing on the other options than this.
So question for the two of you. If there is a mortgage, then there is a wrap, and we saw all the constrictions with the wrap that they cannot be for a FHA or a VA and all of that you pointed out. So the type of seller financing that you would be comfortable with will be the houses that are paid outright.
No, that's a trustee.
Yeah.
An
Okay.
all-inclusive trustee means that there's also a loan.
Okay.
Both of those are fine.
Okay.
This is just another avenue that people are trying. If you are talking to an investor that has an incredible way that they can help your client. They're doing this. They've gone through some investor course.
Yep.
And just to give you some other, most of these investors, they've intentionally chosen not to get a real estate license, or they let their real estate,
Yep.
their real estate license lapse and go. Because you can't do this and maintain your real estate license.
Yeah.
So.
Yep.
There's a lot of stuff there.
So these have been around longer than my father. And I can say that because when my dad was like 6 months old, that's how grandpa bought his house, was with me. That back then, that may be a good way to go with, but with all the contracts, laws and everything. And I remember as a little kid, so the house they bought was on 54 in Timbersville. When they were widening that road, they had to buy a portion of my grandfather's property. And the state did, and he couldn't sell it because he barely paid it off. But the sellers had gone through a divorce, and the wife, her attorney said, don't sign anything.
Oh, no.
And so the state's general attorney contacted her attorney, and they said, if it weren't for
Yeah.
the state buying some property for them,
Yeah.
they would have had one heck of a time getting title to a house they paid off.
Wow. That's really interesting. And of course, the divorce transaction, I have all sorts of, I have a course on that too, because that opens up a whole new can of worms. But yeah, that's interesting. Glad the state was able to get involved and help your dad out with that. And I also thought it was interesting too, how you said that it's been around longer than your dad has. Because I was looking last night and there is actually a state approved form for it, and it hasn't been changed since 1987. Which is funny because in the contract that has so many issues, but I guess the division just threw their hands up and like, if you want to do it, here it is. Like, I mean, even the seller financing addenda was, changed as of last year. And so I just thought it was funny to see the two side by side and what the priorities of the division seems to be on it.
So as an attorney, do you have your own contract for these extra partners?
I don't have, I usually, if it is just related to a real estate transaction that they decided to do seller financing, recommend that they do the Rep C, the seller financing addenda, and then I can help prepare the trust deed and the promissory note. Yep. Okay, so in this type of contract, if there's a mortgage, it's a wrap. So don't be, confused by that. Don't be like Joe Broker who thinks like this can never be found out. And in this contract, the buyer assumes the mortgage in the event of a due on sale clause. That's similar to the seller financing addendum as well. And then it remains in what's called an executory contract period until it's paid, which means the seller maintains legal title to the property, and then the buyer can take possession and they have what's called equitable title. So legal title, who's on the title abstract? What is the county recorder showing as the owner? And then equitable title is this person now has an interest in this real estate because of this contract. And so they have what's called equitable title, meaning that if the seller, you would want to record the UREC, but if the seller decides you see that the property that you have a UREC for has been listed, you could file it or record a notice of interest saying, actually, I'm the one that's supposed to be able to purchase it. And so that's what equitable title gets you. And then once it's paid in full, then the buyer can take the title, and then it's all governed by contract. And that's what Rob mentioned. It's a piece of paper, and paper is great. The fact that it's even written and all of that is wonderful. But in the end of the day, it still would need to be enforced, and it would be enforced exactly what it says in the contract. And in the contract, you want to make sure that you are allocating who's supposed to be paying assessments and taxes and all of that. And then also the buyer is going to warrant that they're not going to put any encumbrances on the property or commit any waste, those types of indemnities.
So,
Uh-huh.
quick question, I mean. What is a wrap specifically? Is it just that there's a mortgage on a seller financing deal?
Yep, so you think
Okay.
about the existing mortgage like a mummy that is wrapped up by the seller financing
Makes sense.
transaction. So it simply means that everybody in that seller financing transaction is acknowledging that there is an encumbrance still on the property and divvy out what needs to be done with it.
Makes.
Yep. Hey, so issues with the UREG. This was brought up, new liens could attach. You definitely want to make sure that there is another title search done before you close on that. Another issue would be if the seller goes into bankruptcy or they quit paying their own mortgage and there's a foreclosure, then the buyer who thinks that they are able to purchase it actually might get evicted from it. And then the seller also, they're still primarily liable for the first mortgage. So if the buyer stops paying, the seller still has to, if they want to avoid any consequences such as foreclosure or even damaged credit. And then it may require, and we'll go over a case in just a moment, but it might require the seller to repay the buyer if it gets terminated prior to conclusion. So UREC enforcement, there are options for buyer default. The first is a forfeiture process. The second is a breach of contract lawsuit. And the third would be a mortgage foreclosure. But the only type of foreclosure you could do is a judicial. It is not a non-judicial. So you have to go through the court regardless. So the process under the UREC, and this is specifically the state approved form, is that there's a notice I don't think that this is the state approved form, but this is a process that you could do. There's a notice of default that you have to give, and then there's a 30-day cure period. And then the seller can elect what remedy they want, which means I could decide to sue you in court for it, or I could decide to sue you for a judicial foreclosure, anything like that. After the remedy has been elected, the buyer technically becomes a tenant at will. You've got to still pursue the remedy. Once the remedy has been granted to you by the court, then you can proceed with an eviction. And so what this typically looks like is, under these types of contracts, you're going to want a buyer to execute a quitclaim deed and hold that in escrow so that if there's a default, then it can be delivered to seller. And that would extinguish any equitable title that they have on it. And as Rob mentioned, I should say mostly not insurable title. I put not insurable title because it is pretty difficult. And as Rob mentioned, there's only one real title company that would do it. And then, as I mentioned, seller does not get to keep all of the payments if it gets terminated, or they might, it depends. It depends on whether or not the court were to find that what they were paid for greatly exceeds whatever damages they're claiming. And so this is actually Bellin versus Malnar. And in 1991, that's where the court said it might not be fair for the seller to be able to keep all payments they've received when they end up getting the property back or end up foreclosing on it or anything like that. And so the court is just kind of looking at weighing the balance between harm suffered by buyer for not being able to get to purchase the property and then whatever harm has occurred to the seller. And so this is the case facts of Bellin. The seller contracts to sell a property for $152,000. Buyer makes a down payment of $23,000, and then seller finances the rest with a contract for deed. Warranty deed for the buyer is placed in escrow to be delivered when final payment is made. A quitclaim deed is also placed in escrow to be delivered to seller in case of buyer default. Buyer makes a total of 76 sum in payments, including the down payment and when the buyer had defaulted. And then pursuant to the forfeiture clause, seller was able able to keep the money already paid. Buyer sued the court, or buyer sued and the court ordered the seller to repay $26,000 of it because it found that allowing the seller to keep all the payments would be what's called unconscionable, aka unfair. And so the seller was only allowed to keep the amount of payments that would cover the taxes and interest never paid by the buyer. And the real question is, what if the seller had actually already paid them? So you got to be careful when you're in these contract for deed situations. If there's a possibility that, you know, if a default could occur, you want to make sure that you're not just going and spending all of that money, which of course, a lot of it's probably going to your mortgage. So it's impossible not to spend any of it, but you do have to keep that in mind is what happens if there's a default and I'm ordered to return some of this, which is probably another reason why these aren't a preferable transaction. The other thing is a breach of contract lawsuit. So you can sue the buyer for damages, saying, you know, not only did I contract to you, but while you were in the property, you damaged it beyond, you know, normal wear and tear, and now I have to deal with this. Or there was another encumbrance placed on the property that, you know, you should be responsible for, or anything like that. And then there's the judicial foreclosure process, which is actually what is the built-in remedy for the UREC, the state-approved UREC. Okay? And the procedure is you do a notice of default, give 30 days to cure that default. Seller rates the note, and so then if they don't cure the default, then you can say everything is due. And then what you have to do, instead of going through non-judicial foreclosure, you have to file a foreclosure lawsuit with the court, which gives a longer, there's actually a 6-month right of redemption in a judicial foreclosure. So it gives a much longer time frame for the buyer to be able to pay it all off. And then if they don't, then after you've been granted a judgment for the foreclosure, then you can pursue an eviction to get them out. And so there's always going to be an eviction at the tail end unless the buyer just leaves willingly. And so not only do you have to worry about enforcing your monetary rights, but you also have to worry about how to get possession of the property back. Okay? And so this is our side-by-side comparison. Whether you're dealing with any sort of deed of trust or a contract for deed, you're always going to have much more clear-cut enforcement for the seller in a trust deed. And then you're going to be able to have insurable title as well. With a contract for deed, many think that it appears to be a good option because, again, it makes sellers feel better that they're still on title. But it may require a title action. It certainly involves more court involvement and all of that. And so I would really recommend, if you can, to do just a deed of trust, whether that's all inclusive or not. So, and we already talked about equitable mortgages. That's just if even if you don't call it a mortgage in any of these documents, if that's basically what it does. An example would be like an absolute deed where you have a contract that governs a loan from seller to buyer, and the seller gives warranty deed to the buyer, and the buyer gives a quitclaim deed to the seller. I mean, it sounds almost just like our UREC example. And then on default, the quitclaim deed does not actually transfer the property back to the seller because the court will find that the seller only has a mortgage and must go through the foreclosure process. And so you need to be careful how you're titling these documents, structuring them, because you don't want to fall into this ambiguous realm where the court has to tell you what it is and that you actually have to do something instead of what you thought you were going to do. And then here's our second case study. So let's say you represent a multi-level marketing genius with an extraordinarily long downline and a high income. He's a big spender and recently filed bankruptcy, so he has difficulty obtaining traditional financing. However, based on his income, he wants to purchase a home in the 1.2 million range. He has $200,000 for a down payment. The seller has a mortgage with $600,000 remaining, and the seller has been transferred for work and is looking for a quick sell. So what do you guys do in this situation?
Can't believe you don't have my clients.
hopefully you're thinking maybe this is a transaction that seller financing might work. And then once you start thinking seller financing, then you have to start thinking about the other considerations we've talked about, like, is there an existing mortgage? Well, there is. We know from this fact pattern that there is. And so then you'd have to do the investigation to find out what type of mortgage is it? Is it something that could be paid off in the transaction? It doesn't sound like with the facts here that it would be. And so if it is an FHA or VA loan, you probably can't do it. But if it isn't, then this might be something that you'd start saying, well, what about seller financing?
Well, and depending on how old the mortgage is, it's 600,000.
That's true.
Uh,
Yep.
If it's.
Or
Not,
25 years into a 30-year mortgage.
well, no, if it's like 5-10 years old, then you know it's a jumbo loan, those are. There are no laws against dropping jumbos.
Sure. Yep. So there's some context clues. So you can definitely, try to figure out what type of loan there is. And also, like I had said, if it was year 25 and a 30-year mortgage, then maybe there isn't a full $600,000. So maybe there is closer to only 200,000, in which case maybe it gets paid off with the down payment. And so those are all things. You don't have to have this is the exact right answer. This is just a hypo to get you thinking if there are scenarios that, someone can't get a traditional financing and the seller is looking for a quick sell. That's when the situation might be something you want to consider. Okay. Let's talk about quickly the seller financing addendum, the approved form. This is something that you would have an addendum to the Rep C. You see on the Rep C when it goes over the purchase price, there is a slot there that you can put in how much would be for seller financing. And then you would if you're ever putting in an amount there, then you always want to do this addendum. And I love that one of the changes they've made to this form is really the disclaimer up top that seller financing is a complex transaction governed by state and federal laws, and real estate brokers are not qualified nor licensed to ensure the terms of the seller financing addendum comply with the laws. And so it's a big disclaimer up front that these can be difficult transactions. You probably want to engage legal services for it. And that's what the next line says, is they're strongly encouraged to consult with a legal professional on it. But once you get past that, you get into the actual terms, and you'll start to put in with the credit documents if you're doing a note and deed of trust, if you're doing a note and all-inclusive trust deed, or if you're doing something else, which could be, the UREC or anything like that. But really stick with the first two boxes. Don't stray into a realm that's fraught with issues. And then you had the creation of documents. So who, buyer or seller, who's going to have the credit documents, which is going to be likely, if you're sticking with 1 and 2, the promissory note and the trust deed. This set is who's going to do it. And then 1.2 gives whoever did not prepare them, or wait, 1.2 is whoever prepared them, they've got to get it to the seller by the seller's disclosure deadline. And then whoever did not prepare them in 1.3, they have a right to take a look and say whether or not they agree to these documents. If they don't agree, then they are not able to work it out, then they are able to cancel by the due diligence deadline. But if they don't, then in 1.4, that's something that's waived. So if there is an issue with the documents, they've got to act pretty quickly to work with the other side to say this is what the issue is, this is how we remedy it. And if they don't, then they give up the right to be able to challenge these credit documents, and then they just become the documents that are part of the transaction. Then you've got the credit terms. You're going to want to say, just like with any old loan, you're going to want to say, what is the principal amount that they're purchasing it for? And then what is the interest rate? Again, if you're the seller, you're going to want a much higher interest rate than what is the rate for traditional financing. And then you're gonna put what the payment terms are. So how much do you want to be paid and how frequently? You can have it per month, you can have it by, monthly or even, every week. It's entirely up to the seller how frequently they want to get paid with it. I'd say it's pretty typical to just see a monthly payment though. And then you have the number of years that it's due in. Again, that's typically 5 years with the balloon payment on the last payment for the end of the 5 years. And then you say when it's due, and then you're going to say what the balloon payment or any other terms might look like. Then you're going to get into the late payments. This is really what you got to think. What happens if this goes sideways? What am I going to be satisfied with if they're late? And so you're going to want to say how many days is considered late. I would say the shorter duration, the better for the seller, obviously. And then you're going to have either a dollar amount of what the late charge is going to be, or you can do a percentage of what is owed. And then you could put in both. You can have one or the other, and then it says which is greater. And then you say also what an additional interest rate would be if there's a default. And then also, this paragraph provides that at settlement, you're going to have, the seller needs to provide the buyer an amortization schedule based on these terms. That way everybody is on the same page about what each of these payment looks like and the interest and all of that. And then as far as taxes and assessments, you're going to decide, is this going to be paid directly to the seller or their escrow agent, or is it going to be paid to the source directly, whether that's the county or the IRS or anything like that. And then you've got the payment, how they're going to be made, if it's going to be made again directly to the seller or an escrow agent. Strongly advised, if this is a mortgage, that you select escrow agent, and then if you do, then you have to put in who the escrow agent is, and then how you're going to divvy up the costs. Is the buyer going to pay for the cost of the escrow? Is seller, are they going to split it? All of that. And then we've got the due on sell provision. This provides that the seller is going to provide the buyer a copy of any underlying mortgage and the amortization schedule, and that the buyer's obligation to purchase is conditioned upon their approval of those documents. And then if the due on sell clause becomes triggered, then the buyer basically becomes responsible to pay the balance of the note on that. And then that payment that they pay towards the mortgage would be credited towards the seller financing transaction. So it wasn't just, oh, you pay off my mortgage and now you still owe me. It's credited as one and the same. And then the buyer, the next few provisions is what the buyer has to provide to the seller to prove that they're, someone that the seller does want to create this arrangement with. And so they have to fill out a financial information sheet that goes over their assets and their debts and all of that. And then they also have to provide the seller a credit report as well. The seller is able to review these disclosures, and then they are able to decide if they want to cancel the contract or continue. They have to do that no later than the due diligence deadline. And then if they don't, then they waive their right to say, I don't like your credit or anything like that. And then again, who's going to buy title insurance? You can divvy that out. And then you're also going to want to provide tax identification numbers for each side at settlement. That way there can be compliance with any mortgage interest filings. And then the last part of it goes into just contact information, and then you can add additional terms and then you sign it. So that is your seller financing addenda, and that is our seller financing course. Does anybody have any questions?